Be ready for dictation. Dictation starts after 5 seconds. Start. In the present case, the principal question that falls for determination before this court is whether the subsequent suit instituted by the plaintiff is barred by the doctrine of res judicata, as embodied under section 11 of the Code of Civil Procedure, 1908. Stop. It is not in dispute that the parties to the present litigation were also parties in the former suit decided by the court of competent jurisdiction. Stop. It further emerges from the record that the matter directly and substantially in issue in the instant suit had already been adjudicated upon and finally decided in the earlier proceedings. Stop. Once such findings have attained finality, this court cannot permit the parties to re-agitate the same cause of action in the guise of a fresh suit. Stop. The Honorable Supreme Court, in a catena of judgments, has reiterated that the doctrine of res judicata is not merely a technical rule of procedure but a rule of public policy, intended to prevent multiplicity of litigation and to ensure finality of judicial pronouncements. Stop. The maxim underlying the doctrine, signifies that a party should not be vexed twice over for the same cause. Stop. The rule also enshrines the principle of judicial discipline, that once a competent court has decided an issue, the same must bind the parties and those claiming under them. Stop. This court is conscious of the fact that the doctrine admits certain well recognized exceptions. Stop. A judgment obtained by fraud or collusion, or one passed by a court lacking jurisdiction, would not operate as res judicata. Stop. However, in the case at hand, no such vitiating factor has been either pleaded or proved. Stop. The earlier decision was rendered by a court of competent jurisdiction, after full contest, and the decree has long since attained finality. Stop. In view of the aforesaid settled legal position, this court has no hesitation in holding that the present suit is squarely hit by the doctrine of res judicata. Stop. Allowing the parties to reopen concluded issues would not only be contrary to law but would also amount to permitting abuse of the process of court. Stop. Dictation ends.